Welcome to the third video in our Essential Guide to Elder Law and Estate Planning series. I'm David, an Elder Law and Estate Planning attorney in DC. In our first video, What is an Estate?, I explained what constitutes an estate, the importance of estate planning, and shared examples of why planning ahead is crucial to avoid costly mistakes and ensure your loved ones are taken care of. In the second video, What is Intestacy? Doing nothing, I delved into the consequences of not having an estate plan and relying on intestacy law. I discussed the various estate planning tools available and illustrated the potential outcomes of intestacy, highlighting the importance of proactive planning to avoid unexpected and often unfair results. In this video, we will explore wills as another estate planning tool and the role they play in the probate process. We will see some of the challenges of having only a will and how it will force your loved ones into court. We will cover the concept of a will, what assets are subject to probate, and the steps involved in probating an estate, from validating the will to paying debts and taxes, and then finally distributing whatever is left over. I will highlight the impact of probate fees and taxes on your estate, all of which underscores why you should engage in trust-based planning to avoid probate and keep your loved ones out of court. By the end of this video, you will understand how a will is but only one estate planning tool, and more importantly, that it does not provide you with a comprehensive solution as a trust-based plan would.
The next example that we're going to talk about is a will. Most people know what a will is. We've all seen it on television. A will is a document, a testamentary document that expresses what you want to happen after you die. Now, I want to tell you that it expresses, it doesn't control. Reason why it's an expression is because ultimately the probate courts have to decide whether or not the will is valid. And if the court decides that it's not valid, then that expression will have no meaning. Furthermore, if there are any ambiguities, then the court will resolve those ambiguities and figure that out. Probate only controls those assets that pass through probate. Assets that pass through probates are those assets that are left in your name at the time that you die, and there is no other owner or person on the title of the account or property. So if you are John Doe and you die with a bank account and there is nobody else on your bank account and you have not used a pay on death, transfer on death designation, then that property must be probated. Now, if you are John Doe and your spouse is Jane Smith, both of your names are on the account, you die, it does not need to go through probate, okay? So we only need a probate property is when the person dies is the only person's name or is the only owner of the property. What is probate? Well, probate is a legal process. As I said, it is the process by which we validate your will and we pay your debts and pay your taxes. And then whatever needs to be distributed, whatever left over will be distributed according to the will. As I just finished saying, probate is the only way to change title to something once you've died. So if you want that property to go to your children, and we need to change your name to your children's name, then we will have to probate the property if we have not done any other planning for you. This is an illustration that shows the estate that we talked about earlier. It goes through the probate process, and at the bottom of that funnel are heirs. But before that property is received by your heirs, there are probate fees and taxes that are siphoned off. And you can see in this example, there are pennies received in exchange for your property, and the dollars are sucked off.